Yes.
May it please your lordship. My lord, I'm seeking your lordship's permission for listing of a writ appeal, my lord, tomorrow, if possible, my lord.
Wait.
After adjourn.
Oh, sorry. Doesn't matter. We'll hear you. But you'll have to satisfy us on the urgency.
My lord.
Yes.
Adjournment request, if any, from item number 1 to 4. Item number 1 to 4, adjournment request. Item number 5 to 14.
In item number 5, we have filed one affidavit in pursuant to the last order that we wanted to call from the section measure. Yes,
Number 5.
obliged,
I
ma'am.
would do that. If not today, then tomorrow we'll see. But nonetheless, bring it fifth matter, we'll take it.
My lord, in item 11, my lord, we are praying for an adjournment on behalf of the
Yes.
state.
Adjournment slip has been circulated, sometimes in February. On behalf of respondent,
Appellant, my lord.
and
Thank
that's
you,
it.
Lordship. Lordship, I'm praying for adjournment.
That's it.
17 February.
Have you taken consent of the other side?
Consent taken.
All right, click now. Yes,
May it
But-
please your lordship, we are
May it please the Lordship. I'm praying for adjournment in item number 9, Lordship.
that's Sikkim matter.
Yes, Lordship.
Why?
Lordship, there's some difficulty on the part of the instructing council, Lordship, who is from
You
Sikkim,
are
Lordship.
appearing for the state of Sikkim.
State of Sikkim, Lordship. I'm for the appeal, Lordship.
What is your name?
DJ Kapil, Lordship.
My lord, I'm appearing for the respondent in this case. We're the writ petitioner. Our writ petition was allowed. There is no stay. And my lord, advertisements are being issued from time to time. Our cases are not being considered.
How's that?
It's going on, my lord.
File a contempt petition.
we have
They can't take this plea. They can't blow hot and cold. They will seek adjournment. They will not have the
Exactly, my lord.
They'll not have the
Several
appeal
occasion
decided.
adjournment has been taken.
Anyway, next date, if they don't do, press for.
May I pray
on
for
the-
an observation, my lord? That lordship will clarify that there is no stay of the judgment.
In fact, Lordship, on the last occasion, we had started, Lordship, but the other side was not there. That's why the matter was adjourned, Lordship.
Now, next time, Mr. Kapil,
Lordship.
ensure that the matter is argued.
Lordship. Let us fix a date,
We
Lordship.
try our best not to delay anything from our side,
Yes, Lordship. True.
right?
Right.
Mr. Chaudhary, wait for
On 6th of January, my lord.
no, that is too early. We'll keep it in February.
First week of February, Lordship.
That's too early. This is with respect to classification of Sikkimese original inhabitants or something,
Yes.
royal subject, loyal.
My lord, my lord, there are accrued rights under the statute. By an
We heard you
executive
being-
order, these are sought to be taken away.
No.
That's the point. It boils down to that.
Mr. Chaudhary, there are other issues which perhaps is required to be gone into. The contents of the merger
Merger.
and on the annual of Article
My
14
lord,
and 16.
my lord, under the regime of the king, my lord, of Sikkim, the Sogal, in
Sogal.
fact, my lord, the government servants were given preference over the person who were born there. That's the, and we are all, my lord, and his grandson, children and children of government servant who served the kingdom before 769.
There is some urgency in the matter, Mr. Kapil.
Yes,
Lordship.
Because if you had not been continuing with the appointment process, perhaps yes,
yes.
otherwise not.
My lord, one person has committed
You may-
suicide
you
because he
may-
could not
May
participate.
or may not succeed, but this appeal must be disposed of.
Yes.
Yes, Lordship. On the first week of February, Lordship.
First week of February, Mr. Chaudhary. Yeah, prayer for adjournment has been made on behalf of the state of Sikkim / appellant by Mr. Kapil, learned advocate. However, Mr. Ken Chaudhary, learned senior advocate appearing for the respondent, objects to the time on the ground that there is no stay of the impugned judgment and the state of Sikkim is continuing with its appointment process in various departments of the government. Let this matter be listed with priority.
8th of February.
Huh?
5 to. 8th of
Or I could- Yeah.
Last week of January,
17th.
17th of Feb. Is it too late?
yes.
10th of Feb.
10th.
Has to be a Wednesday,
It's a
10th.
Tuesday. It's a Tuesday, Lordship.
Tuesday.
Tuesday.
Highly request.
Yes. Any other matter? Yes.
May it please your lordship, I am appearing for item number 12 with the consent of the others.
Item number 12.
Yes.
12, you are appearing for whom?
Respondent number 6.
No, we need to hear the appellant.
Mr. K. N. Chaudhary, the senior counsel.
He was here, no? He just,
M.K. Chaudhary.
Mr. M.K. Chaudhary, not Ken.
No, this, I'm appearing for Mr. P. Sekia, his senior.
What do you want? Have you informed the other side?
Huh?
Have you
The
informed
other-
the appellant?
His lordship,
Yes.
we've been informed.
Oh. A prayer for adjournment after having taken consent from the counsel for the appellant has been made by the counsel for the respondent on grounds of personal difficulty. Let this matter come up for consideration, and then it goes in January,
January
February, sorry.
19 February.
19.
It's the same matter where somebody was appointed principal, the appointment was cancelled. We have heard this matter, no?
Yes.
Yes, lordship.
May I please your lordship? Lordship, I beg to mention item number 19 of the SL list for an
19.
adjournment. 19.
Item number 19, where is the list?
Supplementary list.
Why do you want time?
Lordship, the
Admission, why do you want time?
leading counsel, Mr. R. Chakraborty, has some personal difficulty. Item number 19.
Then you shouldn't file applications anyway. Any objection?
No, my lord.
As prayed for on behalf of the writ petitioner, let this matter come up for consideration on. Again, it goes in February now. January is all full.
4th of February.
Yes, now you make your mention.
My lord, the urgency is that, my
Now,
lord.
what do you want? You want a writ appeal to be listed?
Yes, my lord.
Yes, and what is the urgency?
Urgency is this, my lord, the order assailed of the single judge requires us to dismantle the part of the property, and that the time given was 1 month, which expires on 13th, my lord.
Why did you take so long? to
My lord,
come
we
to-
filed it on 28th of November.
All right,
itself.
and why was that order passed? Were
Actually,
you an encroacher?
no, my lord.
Then what
We
happened?
are patta holders, my lord. The land records are in our name. We obtained due permission from the authorities and made the construction.
Hmm.
Now, after, my lord, they are claiming the municipal authorities suddenly dismantled part of our property. I came before this court.
Hmm.
Now,
Without issuing a red line and without issuing notice?
nothing, my lord. Everything was in patta, everything in the land.
No,
So-
but they
excavating
continued with
without
demolition
notice.
without noticing you.
Without notice. I came before this court.
Is that possible? You are staying in that house, no?
Yes, my lord.
Yeah.
And then, my lord, what happened?
A violation of building norms, all right.
No,
may have-
no, but they are not alleging violation of building. norm.
What is the
They are-
ground on which?
They are saying that this, the settlement order, which was granted in 1991, that has been modified in 1992 during the lifetime of the
Original holder.
original owner.
Mhm.
Now, that is not within our knowledge. They are claiming that it is within our knowledge, that this order, it was supplied by virtue of this honorable.
All right,
court's
tomorrow.
order. My lord,
Inform the council from the other side.
my lord.
The municipal corporation lawyer.
These two measures, the writ petition against the Armed Forces Tribunal, Malak, the notice was issued way back in September and October 2024, and interim order is returnable. But till that, it was not listed, Malak. Can it be on Friday, Malak?
Next week, we'll have.
But-
All right. Returnable date, even if the notice has not been served, it must come on board. Otherwise, it gets detracked. When we fix a date, it should come on that day. Acha, these are old matters. We fix date and on that date the matter comes. Therefore, it is never
This is
detracked.
a pending case where
Pending.
notice was issued, but they
Then
took,
let it come in January.
so there's an urgency. That is why my
What can
humble.
be urgency in an armed force tribunal? It
Well,
must be with respect to pension, invalid
As per
pension.
my instruction, they, Malak.
What is the issue?
Malak, the same issue Yolos is already.
Invalid pension, what is that? Disability pension. These are
Malad,
the issues
Malad,
which are decided.
Malad,
Where is
Malad.
the urgency? No, January. Give your slip. He will.
Malak.
And then before any bench, Mr. Advocate, this is for consumption of the entire bar.
Malad.
Where the matter is being adjourned, you please remind the court. Mr. Counsel, I'm talking to you. You are
Malad.
making your exit.
Malak.
If you make your exit like this, how will you have a date?
I just come to the.
I'm talking to you. Of
Malad.
course, this communication is for
Malad.
the consumption of the bar
Malak.
in its entirety. But when a matter is being adjourned, please request the judge to give a day.
What?
Huh? No. Because you can tell the court that the NCMS committee has recommended it. Right, many times I would also forget to fix a date.
Wow.
But then I'll be issuing necessary instructions through the registry to all the court masters that a date has to be given. On
Wow.
that date, the case must be placed.
Wow.
Whether it is argued or it is not argued, but it must be placed on that. Correct?
Fine.
All right.
8 January.
Yes, okay. Yes, follow. Yes.
Daily list for orders. Item 1 to 3.
What has it come from?
In this case, my lord, item number 1, last occasion, the honorable court asked the respondent side to place the published notification.
No,
of
what
the-
is the issue? I've forgotten. I've not.
Issue,
seen.
my
I
lord,
don't see
the-
orders file.
We have alleged that without publication of the notification in the Gazette,
Hmm.
they have acted upon it, my lord, and issued their impugn advertisement, which is put to challenge in the Miss case. And the
Okay,
main
the
issue,
Assam Elementary Education Provincialization Amendment Rules 2025 has not been notified.
not notified yet.
How are you acting on that?
That instruction I'm yet to get, my lord. That is why, my lord, a communication was received from the department, my lord. They're
What
seeking
is this
3 days.
communication?
They're seeking 3 days time, my lord.
Unforeseen technical reasons they required in one information. Why has it not been notified? If it has, we are not asking you to notify it. We are only asking you to tell us whether you have initiated a process under the rules without notifying it.
Process was initiated, my lord, because advertisement was issued. But whether it is notified or not, that information
So
I.
this
should get it.
information, you don't require any technical expertise to tell the court.
My lord,
This is
This is the
this is
communication.
yes or no answer.
This is the communication I have received from the department, my lord.
Therefore, communication doesn't mean any sense, make any sense to us. For technical reasons, we are not able to, I mean, you say yes or no, we will decide. Anyway, then it
Like,
goes, then it goes in January, mister.
My lord, one thing, my lord, the impugn advertisement may be suspended for time being, because
That we will not do.
my
Otherwise,
lord, because my lord, we have annexed the page number. 20.
Suppose these rules have not been notified. What does the advertisement say? Does it say that pursuant to these rules?
Yes, lord.
Where is that?
At page 30, my lord. That is the thing.
Why can't you in the meantime notify the rules? Why can't you notify Mr. Khataniar? Why can't you advise your client to notify? We don't want to stall the process
Exactly,
of
my lord. That is why,
appointment.
my lord, I'm praying for 3 days time, my lord. My lord may fix it on next Monday.
As prayed for on behalf of, what is it, department?
Department of School Education. Department of
Department of School Education.
On behalf of Department of School Education, the matter is adjourned to Monday next.
Oblige.
15-12. Item 4.
Now you are, Mr. Khataniar, if you don't tell us, then we stay the process of appointment.
Monday by Monday, my lord. Oblige, lordship.
By Monday, your time, you notify.
Oblige, lordship.
Item number 4. Adjournment.
Take a adjournment request. Give a date.
12th of February. Item 5.
Affidavit has come. Affidavit has come. That's now they may be mentioned.
Whatever.
May please go.
Yes.
My lord, in this matter, I was, as per the previous order, I was supposed to file an affidavit in regard to this. My lord, the authorized signatory is currently unwell, because of which she was unable to sign and send it to me. My lord,
Doesn't matter. We pass it over. Come tomorrow.
my lord,
We pass it over. Come tomorrow.
my lord, she's residing in Siliguri. That's why it has to be sent from Siliguri.
It's your business. No, it's the return of EMD.
Yes, my lord.
No, but who is the appellant here? You're the appellant.
Yes, my lord.
And where is
We,
Mr.
we,
Dubey?
we filed our affidavit yesterday, my lord. That has been called for, my lord. It will take some few minutes to come in.
Share it with him.
I've received, I've received.
Anyway, you want what? Modification we can do.
My lord.
We can modulate, we can take in your oral prayers and we can modify.
Yes.
Don't take a longer time. We just want to finish off whichever matter we have heard.
Right.
Hmm.
Right.
I think we have almost dictated the entire judgment.
Yes, my lord.
So,
My lord, I would like to differ, my lord. I would like to convince your lordship, my lord.
All right.
That's why I filed an affidavit, my lord.
all right, all right. All right. Look here, as prayed for on behalf of the appellant, re-notify, then it goes in January.
Obliged, my lord.
4th
As
February.
on behalf of the appellant and agreed to by the counsel for the respondent, let this matter come up for consideration in January.
4th of February.
Obliged, my lord.
4th of February.
Much obliged.
Oh, it's in February now.
Sorry. Item number 6.
Your Honor, I'm appearing for respondent number 4 in this case.
Yes.
Your lordship will kindly see the, here is the earlier order, my lord.
Earlier order dated?
The latest one, my lord.
Earlier order dated? 14/11.
Yes.
Right, okay, okay.
So,
Affidavit has been filed by respondents number 2 to 4. Very difficult. What does this mean? I don't understand.
my lord,
Who has filed affidavit on whose behalf? Who is interested in filing?
my lord,
affidavit?
only respondent number 1 was directed,
You have to make out a case, sir.
my lord,
You have to make out a case first
My-
before I issue notice.
my lord.
If we think that your matter is worth considering, we will issue notice.
My lord.
You're Mr. Gayan. You're Mr. Gayan. He's choose Gayan. Who is the what is?
My lord,
Yes,
I have brought one short note for your lordship. So that,
short notes later, but then you tell us
No.
what is the matter.
no, what happens, my lord, here, one, respondent number 1 to 5,
State is not,
they are,
it's the central legislation which is. Yes,
they are all, my lord, the central government, enactments, acts,
tell us one thing.
my lord,
Tell us one thing.
my lord.
All these acts, central acts,
Yes, my lord,
under entry 66, rule 1,
my lord.
entry 1
Yes, my lord.
of list 1.
List 1,
Now, these regulations are under the Central Act,
my lord.
laid before the Parliament, requiring the state to give the essentiality certificate. Where is the state insisting for it?
Only, my lord,
You're concerned with this essentiality certificate.
I am
from the
concerned,
state.
my lord, with, not with the main act, only the executive
You can't.
regulation.
On what ground? These are
Hmm.
prescriptive, requirements under the rules. How do you challenge it? You must say that it is perverse, arbitrary. The
Yes.
state should not do. See, geographical location, state partnership, and there are many other things. The entire law is against you. What are you asking for? I thought perhaps in the beginning, when I saw this file, I thought that it was for the purposes, the state was unnecessarily insisting. It is the prescription of the Central Act that don't permit anything without the essentiality certificate by the state. So this is the Central Act. Where is the question of not following it? And what is so unconstitutional about it? We'll tell you the judgment.
My lord, the imposition of certain conditions by,
Not at all. Not at all. Essentiality certificate is necessary.
Yeah.
Therefore, I said,
Yeah.
why to ask for counter affidavit? You tell us any law which says on this ground, on geographical things, state participation, you can challenge it. I'll tell you the exact judgment. It has been decided.
my lord, that controls the main provision of the main act, the executive regulations. They say that you take no objection certificate from the state first, then you apply for starting a college. So this is the, my lord, crux of the matter, and Honorable Supreme Court, in the certain cases, my lord, they have said that yes, that cannot be controlled by external, my lord.
No, don't use Supreme Court casually, name of Supreme Court casually. You can't.
And this, I have also brought to your notice, Lordship, there are certain other central enactments which does not require state governments.
Doesn't matter.
No.
The state's role, Supreme Court says in so many words, the state's role here, while giving essentiality certificate, is auxiliary. It is not determinative. And therefore, the parent body, it has required the essentiality certificate considering the assessment of feasibility, local needs, public health considerations, infrastructure and hospital availability, no objection on land and policy alignment. How can you say it is bad? It hits Article 14, 16, I don't know, 19.
That has been explained by Supreme Court like this, my lord, that if at all has the power, the central parliament has the power. It can do that.
Where the state legislature has introduced it? State legislature has not introduced it. Perhaps you are confusing with something. The state legislature has not done anything.
Not seeking permission or no objection certificate or essentiality certificate from the state is beyond the scope of the main act.
I'm not getting that judgment. There is a straightaway judgment. It started from 2005 Adhiyaman. Are you aware of that?
Yeah, my lord, at that particular point of time, this
State of Tamil Nadu versus Adhiyaman Educational and Research Institute. They admit that higher education standards fall exclusively under Interest 66 Rule 1, List 1. States cannot prescribe any additional or inconsistent standards. Here, you don't have a platform to stand because this is not created by the state. It is by, unless you say that a state has made a special law aligning it with the central government, we will consider it. How is it unconstitutional if an essentiality certificate is asked for? How is it putting you to any difficulty? You can say that because I hail from a different community, the state is not, but that is your presumption. We can't declare a constitutional provision or a statutory provision unconstitutional on your presumptions. Suppose your application is rejected.
Yes.
Just a minute. If your application is rejected, you can come back to the courts. That's why essentiality certificate is not being given to us.
Only one point, I understand your lordship's mind. In this case, Pharmacy Council of India, there are three of my note number. It has been reported in 2023 CSCC.
What does it say? नहीं है. If it causes unnecessary burden, but to align with the state responsibility, constitutionality. Your fear that you will not be given a essentiality certificate is no ground to question the correctness of the statute. No, that's not wrong. Perhaps you have made some erroneous statement in your petition which is creating confusion. But we examine the matter, but it is only under the parent act that the essentiality certificate is required from the state. State of Assam has not asked for it, like what had happened in Gokul Institute, which was struck down.
My lord, what happens, my lord?
If you want more preparation on the subject with more case laws, I'm not asking for any counter affidavit. Unless you satisfy me that it requires consideration. Why should I ask for counter affidavit unnecessarily, waste of pages? You want more preparation, we can grant you time.
No. your lordship, I leave it to your lordship.
When we will say, while dismissing your petition, we will say, in case essentiality certificate is not given to you, you can come back to us. Correct? That should satisfy you. This on your apprehension, I understand, because there are few paragraphs.
If I have a case, my lord, I can come. If I do not have, how can I come?
Only the apprehension.
Yes.
Can a statute be questioned on your apprehension?
My lord, they tried to nip in the bud of the chances of opening a college.
We
They said
understand.
that you bring it first.
Look at us.
My lord.
Look at our remit. We cannot go beyond our constitutional remit now. So even if it is a fact, unless we find the prescription to be bad or its execution to be faulty, can we interfere? That's the question. Suppose you want to open a dental college and the state government in its wisdom says that no, you can't. We will not give you certificate.
Because
Just a
the
minute.
state government do not have that power to start a dental college. It is a central act which gives the power.
We have followed that.
So
It is
it
under
is, state government, even if they can, they try, they cannot.
And I was giving a hypothetical example.
No.
Suppose you want to open a dental college, which is governed by the dental council. But dental council says that you can't open it unless you have the state essentiality certificate, right? You apply before the state refuses it on some ground. That is questionable. That can be questioned,
Right.
but not the prescription itself. I think I have made myself clear to you.
Right.
Dismissed.
Obliged.
Give your appearance slip. You have argued, you have made short notes,
Mine.
but when you promise to give counter affidavit, you must give.
Lordship, we have already filed by National
No,
Medical
they have,
Commission.
only respondent one has not filed.
Item number 7.
Please, Your Lordships, I beg to appear through VC, Your Lordships. On last date, I sought some time to file judgments, Your Lordships. I'm sorry, I tried my best, but I could not lay my hands on any judgment.
What is this case about? Have you said something?
Here, Your Lordship, yes, please, Your Lordships had passed a detailed order on last occasion, Your Lord. I am here, I'm seeking Your Lordship's invalid pension as well as disability pension. I'm already,
Your MS Avasthi.
please, Your Lordships.
MS Avasthi, that day we adjourned the matter in deference of your great efforts to argue the case. But
Please,
we are
Your-
absolutely sure about this aspect of the matter unless you prove it otherwise,
Please,
that you can't, nobody can have both the pension elements together. There would be no difficulty in your asking for your invalid pension to be converted into disability pension.
please, Your
There's no
Lordship.
difficulty. You go before the authorities, say that let my, under this changed, medical condition, where my rheumatoid arthritis, that also is doubtful because it depends upon the percentage of disability, number one, and the aggravating cause should be your employment. But before that, there is no proof of the fact that you, the disease was aggravated while you were in service. You had already taken an invalid pension.
Although medical certificate has been issued in this regard, Your Lordships.
A certificate can be given by a doctor that, well, the blood pressure is fluctuating. What can
And-
be done? So,
and-
but the assessment is that your disability is 40%.
Please, Your Lordship.
That was the content on which you were given invalid pension.
Please, Your Lordship.
Now, because the doctor says you impressed upon the doctor that this rise in the, this rheumatoid pain has increased, maybe it is because of your assignment in your organization. Can that certificate be used for giving you two pensions? And where is the provision under law to have two elements of pension? There are cases, I agree, before the Armed Forces Tribunal where they add the disability content and that. We had asked you for your case laws, but no
Please,
such
Lord.
work. What do we do?
So sorry, I could not put my hands on any judgment, Your Lordships. Your Lordships may.
These are all Armed Forces Tribunal ad hoc decisions that please pay him that content 40%. We will not perpetuate that. Sorry to say, but we will not perpetuate that.
Because
Whereas, with respect to law, there should not be any twisting of facts.
please, Your Lordships.
So you want to conclude or you want to argue for other thing? We are not inclined to grant you anything.
Then I
We
leave
are-
it to my
We are
lords.
agreeing with the cat still.
Because on facts, I have already argued on last occasion, lordships. Then I leave it to my lords. Your lordships may then give me liberty to approach before department to
All right.
make
With the liberty.
get my pension into
Dismissed with the liberty.
Please, your lordship. I'm so grateful. Your lordship may observe in order to make a representation before department. Otherwise, it will
We
come
won't say
on
that.
my
So
way,
you
your
require- We'll say that it will be open for the petitioner. We are not directing you to go.
Then your lordship may observe in the order. Please,
Huh?
your lordship may give me liberty to approach again in case I'm agree with lordships.
We'll say that it is open for a person to ask for conversion. Nothing else.
Please, your lordship. I'm so grateful.
Yes, Mr. Chakravarti, any
If the law,
difference of opinion?
if the law permits, Lord.
If the law permits.
Please, your lordship. I'm so grateful.
Supplementary list.
Yes.
Chamber.
We'll do it just.
Sup- Supplementary list, item 17 for admission.
Meet please, Your
Yes, who appears for respond number? Who is the officer?
Below, I'm appearing for the.
Yes. Now, we are not questioning that part of the judgment, though it is also questionable. Removing that, quashing that observation that it is without evidence. Because for the reason, we would not have done it, for the reason that it is not punitive, it is only prescriptive, descriptive. But then, since the entire inquiry under ICC was curtailed, therefore, that observation is uncalled for. To avoid disturbance in the workplace, there was a conciliation. But which law says that the minimum protection which is provided under POSH 2013 would be a complete, ban on the department proceeding against you?
My lord,
The learned single judge forced both.
my lord.
But I don't think it's correct proposition of law. We will not disturb the first part of the order where that observation has been avoided. We will say that it is a curtailed inquiry. Therefore, the ICC committee should not have made that. comment.
Yes,
Therefore, we say that
that was not required, in fact.
that was not required. And therefore, we are not even noticing the victim. We don't want to notice the victim. Unnecessarily harassment. But inquiry should commence. A departmental proceeding should
At
commence.
page 196, my lord, may kindly come to page 196 of this is of the impugned judgment.
Yeah, but when we observe certain things, don't think that it is a final opinion. You can always argue. Huh? So therefore, don't misunderstand us.
My lord.
We only channelize what point you have to focus on.
My lord.
196. Yes.
At page 196, at para 9, is part of the judgment of the learned single judge.
Actually, it's part of the judgment. Para?
9, my lord. And here, my lord, the complainant has appeared and made the submission at para 9. So and so learned counsel for the respondent number 7 has also fairly submits that the respondent number 7 has indeed written the letter dated 25/2/2021 to modify the concluding part of the ICC report, wherein it was stated that due to lack of evidence, proof, witness, no conclusion could be made regarding the complaint dated 24/1/2020.
All right.
She submits that the petitioner had all the evidence and evidences and had submitted the same before the authorities, and therefore the observation made in the conclusion has affected the dignity and reputation of the respondent number 7, by way of which her integrity and reputation is questioned as on today. She therefore submits that the petitioner only wants to maintain her dignity, reputation, and integrity by having the concluding part of the inquiry report modified. She's not against the conclusions that arrived at by the ICC, my lord.
That's right.
She's only agreed by the.
Can she prevent the department, the employer to proceed against somebody.
My lord, as per the act itself,
10-4 does 10-4 of the act.
my lord,
That is for a fresh ICC inquiry. It is limited for that. Read that.
no, 10-4, my lord,
10-4 prohibits only second inquiry by the same committee.
by the same committee,
So this is not an inquiry by the same committee.
my lord. But now at section
The
13, my lord,
department, without the complaint of the complainant, the victim, the department wants to penalize you.
my lord,
Face it, we can't help it.
my lord, I'll just come to the
Face it, we can't help it. If the charge is the same, the lady must say no.
this at section, my lord, I'll just read section 13, my lord. Section 13,
Posh Act 2013. Posh 2013.
section 13, subsection 2, my lord. Where the internal committee or the local committee, as the case may be, arrives at the conclusion. I'm sorry.
Yes. Arise or read.
Where the internal, this is section 13, subsection 2.
Hmm.
Where the internal committee or the local committee, as the case may be, arrives at the conclusion that the allegation against the respondent has not been proved, it shall recommend to the employer and the district officer that no action is required to be taken in the matter. And
That's under this act, no. Read 19 of the act. Read 19 of the act.
the duties of the employer
Read it, please.
the relevant subsection is at subsection I, my lord. Treats sexual harassment as a misconduct under the service rules and
No, not even that. We would like you to read the other part.
section
What is
9,
the obligation of the employer? 19 is
duties of the employer.
First one, every employer shall provide a safe working environment at the workplace, which shall include safety from persons coming into contact at the workplace.
My lord.
Now, you have a bad reputation.
My lord.
Right.
My lord.
So the employer has an obligation to try you departmentally and find out whether this allegation was correct or it was conjured up only for the purpose because you are the immediate superior. Not immediate superior, you are the supervising authority of the woman.
My lord.
This observation part, that was
There was a misunderstanding, my lord, and I have apologized. There was a conciliation.
that's all right, but the department does not believe it. Can we cut their powers? Can we curtail their powers?
My lord, as per
Suppose without the lady commenting, without the lady communicating to you, to the department, the employer says that no, we have heard from rumors. This is the charge, you face departmental proceeding. Can it be stopped?
my lord, with utmost respect, if I may say so, this special act has been specifically brought into effect.
Therefore, we use the word, not me, all the cases decided under Posh 13, and then parallelly departmental proceeding of criminal cases, they say that this Posh 2013 is the minimum protection for sexual harassment.
It's not.
It can't, preclude other forums to operate against the male factor.
Had the ICC come to a conclusion
Give me one law.
proving misconduct,
Give me
then
one law
my lord,
which says that once ICC has taken up the matter has been conciliated. This conciliation, Mr. Counsel, you must understand, it is not compounding. It is different from compounding what you used,
My lord.
what you saw in under section 320, earlier 320 of the Code of Criminal Procedure.
my lord,
This is not compounding. This is conciliation to avoid any confrontation at the workplace,
my
to make it safe.
my lord, and the authorities employees have transferred it out since already gone from the office. My lord, on this very point, there are no case
How many
law
years of
as such.
service? They are not going to dismiss you.
But my lord, there's a judgment of the division bench of the Madras High Court, which has taken into account the cases of Sakshi and the Vishaga guidelines.
Tell us any provision of law which permits the courts to interfere in a departmental proceeding initiated against an employee. Finished.
Because
background facts we forget.
my lord,
The unnecessary judgments.
my lord, the ICC.
Suresh Kumar. Which paragraph of the judgment?
My lord, may come to para 31, my lord.
Para 31.
My lord. or my Lord may kindly come to para 32 subsequently. If I may read it, my Lord. A reading of the judgment of the Honorable Apex Court in the case of Medha Kotwal Lele referred supra, particularly paragraph 44.1, which had been extracted supra. It had held that the findings and the report of the complaints committee shall not be treated as a mere preliminary investigation or an inquiry leading to a disciplinary action, but should also be treated as a finding report in an inquiry into the misconduct of the delinquent in sexual harassment cases. It has mandated that such procedures should be incorporated in the service rules. At 33, my Lord, the Honorable Apex Court in the case of Union of India versus Dilip Paul reported in so-and-so, after referring to
Look at the extracted paragraphs. In what context has it been said?
no, my Lord,
Paragraph 75 and 76, what has been extracted on the next page.
My Lord, then
that was with respect to the committee behaving like a disciplinary authority and asking questions. So does it mean that the department, where does Guna Sekaran judgment go?
I'm coming to that at para 35, my Lord. From the conjoint reading of the judgment of the Apex Court extracted supra, we are of the view that the disciplinary authority is bound by the findings of fact given by the Internal Complaints Committee, with the second respondent therein. The second respondent is a fact-finding inquiry authority, and the report of the committee is held to be a report of an inquiry authority based upon which a disciplinary action by the first respondent can be initiated. If the arguments of the learned counsel appearing for the appellants are to be accepted.
These are two different things.
My Lord.
Here was a case where the ICC recorded its finding that the person is guilty and recommended for departmental action. ICC cannot dismiss an employee. Correct. So therefore,
has to be held.
that finding is there. But here the entire inquiry was curtailed because of conciliation.
My Lord, and there's
So
no.
therefore, how does paragraph 35 help you?
My Lord, there's no. In my case, my Lord, the ICC, there's no recommendation of the ICC, no findings of the ICC.
So therefore, we say forget the facts. No legend here. Straight away, because the second time, see what has happened. There is a lady who is working under you.
My Lord.
She makes a complaint to the ICC, to the committee. ICC holds an inquiry. During the process of inquiry, you and that lady officer, they think that it is unnecessarily getting on their nerves, getting on her nerves. She should complete it. She should curtail it. She says that I'm ready for a settlement, a conciliation, subject to the employer not posting you along with her. She agreed. Then when she read that report of the ICC which says that there is no evidence, she says that no, there is evidence. These are screenshots of the messages. Let you investigate again. Conciliation doesn't mean compounding. I have not compounded. I did not tell lies. Just a minute. Let me complete. If my appreciation of facts are incorrect, tell me. Now, this lady says that please have the inquiry. It is not without evidence that I allege. ICC refuses to have second inquiry because they are bound by 10(4). Correct? And then the department takes up. Where is the constitutional bar? Where is the statutory bar? This is how we understand the fact. You tell us.
My Lord, the ICC stands on a higher footing than a disciplinary authority.
Who says so?
My Lord, the ICC has been conferred with the powers of the powers of the
That
CPC.
position is absolutely unacceptable. ICC recommending action, the matter goes to the disciplinary authority.
It has not recommended, man. There's no recommendation, my Lord. ICC has closed the matter.
I think we are repeating. You are repeating.
My Lord, the only grievance of the complainant is that this particular observation of no evidence should be deleted.
Suppose a lady officer goes to the employer and says that even though this Mr. X has been harassing me, but I don't want to prosecute, please don't trouble him. Don't put him to departmental inquiry. Is the employer bound by such a request? I have put it in a different way. Not the cart before the horse, but in a different way. I have put the entire carriage in a different causeway.
My Lord, disciplinary authorities inquiry is an independent inquiry. That is there, my Lord. But there has been no recommendation.
And this, look at this background. The ICC should not have said that there is no evidence. This irked the lady. Otherwise it will be an adverse comment on her character.
And my lord,
Without any evidence, she was alleging something against a
my lord,
employee.
in my submission, that is why the learned single judges,
Suppose, hypothetically, we look at a case from all angles so that nobody is put to any disadvantage. And if you have slightest of the point, we will expand that point and we will try and enter into that field. That's our approach. I don't know whether you people have noticed it or not, but if you give me the space, we will enter into it. Now, suppose we issue notice to the complainant. Suppose she would come and say what?
she would make this.
Do you expect that she will say that, no, I don't want even this inquiry to be conducted for the reason that it will remind me of that old harassment, and there is something called right to be forgotten. As long as this inquiry continues, this allegation will keep on popping up, and so therefore I'll be mentally disturbed. Can she say that?
I believe she'll stick to what was observed in paragraph 9 of the learned single judges order.
Do you want that we should test that by issuing notice to her? Which we are not going to do. We are only testing your confidence.
No, my lord, I'm sure she would like to close she has already closed the matter. Her only grievance is, my lord, I'm repeating that again, my lord. Her only grievance is that this should be deleted because I had produced evidence, but I don't want to continue further because.
We can say that the departmental proceeding will take into account this fact, but no, that also would be beyond our remit. We don't want to pass any order which is beyond the powers given to us under 226 or the appellate jurisdiction. We are not finding this order to be sustainable of stopping the departmental. You can argue one thing, Mr. Counsel. We can suggest you this. You say that this report is an integrated report which could not have been severed. And therefore, the single judge was not right in not accepting one part of it and accepting the other part of it. Maybe, but that also will not, you'll not go beyond
because we did not proceed beyond the conciliation proceeding because there's no evidence adduced because both of us sat together.
Filed a preemptive writ petition, you got an order.
My lord,
it was a preemptive writ. In fact, the petition should have been dismissed, saying it to be premature.
Because this inquiry, but there is notice for disciplinary inquiry came as a bolt from the blue for me. Because, my lord, because this whole thing was settled, the complainant was transferred out, the whole thing was forgotten.
All right, we allow this. Give your appearance. We have focused so much on these facts right now. The application stands allowed. The departmental proceeding shall continue from the stage where it was stopped. You can't help. Yes.
Item 18.
No. हम यहाँ लिखा ही नहीं रहे इसलिए फंस गए यहाँ नहीं लिखा रहा है पास चल रहा है यस तीनों दे दो हमको लिखा हुआ है yes
before the appellate tribunal the issue is about the condonation.
Yes, Lordship, I have gone to the judgment that Lordship has discussed. Yes,
Banarsi Das.
Yes, not the other judgment, Lordship. Narayan Chandra Ghosh. Lordship, there's a slight difference.
Narayan Chandra Ghosh.
Narayan Chandra Ghosh. Lordship, there's a slight difference in the amount to be deposited under the SARFAESI Act and one under the DRT Act. Here is a case which pertains to the DRT Act, the recovery of debt due to bank and financial institution act. Lordship, section 20 is very relevant, Lordship. 20 and 21, Lordship. May I just read section 20, Lordship?
Yes.
Yes. Section 20, Lordship. Save as provided in
section 20 of DRT.
DRT Act, Lordship. Recovery of debts and bankruptcy Act.
DRT Act.
1993. recovery of debts and bankruptcy.
I read that in the meantime.
Lordship, save as provided in section 2, any person aggrieved by an order made or deemed to have been made by a tribunal under this act may prefer an appeal to an appellate tribunal having jurisdiction in the matter. Then, Lordship, I will take to section 21.
Yes.
Deposit of the amount of debt dues on filing an appeal. Where an appeal is preferred by any person from whom the amount of debt is due to a bank or a financial institution or a consortium of bank or financial institution, such appeals shall not be entertained by the appellate tribunal unless the person has deposited with the appellate tribunal 50% of the
That's all right. That's all right.
amounts of
Hey,
debt.
just a minute, Mr. Counsel. You read 21 again, the first 3 lines.
21, Lordship. The last portion of 20.
Forget about the last portion. That's the requirement, the prerequisite of depositing thereof. Read this amount.
That's one.
Where an appeal is preferred by any person from whom the amount of debt is due to a bank. Has that been decided by DRT?
Yes, Lordship, by way of a judgment under section 19. That's section 21 says so, Lordship. Lordship, I'm just reading the last portion of section 21. It will, Lordship, clear the Lordship issue. Such appeal shall not be entertained by the appellate tribunal unless such person has deposited with the appellate tribunal 50% of the amounts of debt so due from him as determined by the tribunal under section 19. Determined. Lordship, judgment has been delivered. Lordship, it's a judgment on contest. Lordship will find.
Okay, all right. Judgment on context. What is the order which is being challenged?
The order that is being challenged before the learned tribunal was that he wants to challenge the judgment, Lordship, passed by the learned tribunal on the ground that, Lordship, he has alleged is an ex parte judgment, Lordship, along with an application for condonation of delay. His application for condonation of delay was not
Did he file any review petition?
Did not.
What petition did he file?
Lordship, he filed an application for setting aside the ex parte judgment. It was not an ex parte judgment. It's a judgment.
13 application.
Yes,
Would that be applicable there?
Lordship.
He must have filed review. Was he not heard?
Lordship, he was heard, Lordship. He has filed his written statement. It was a judgment passed on contest.
Judgment has been passed.
Judgment has been passed.
And that application, let's see the order passed.
Yes, Lordship.
Otherwise, then it will be difficult.
Lordship, page 49 is a judgment, Lordship.
All the delay.
Different.
This is then different.
Page 49 is a judgment, Lordship.
All right. Which application was rejected? By which order? What is the impugned judgment?
Lordship, the impugned judgment that was passed.
Which impugned judgment not here? The impugned judgment of the
DRT. DRT, Lordship, he filed
impugned
a
judgment of DRT and then DRA.
Lordship, DRT, Lordship, he filed an application for
Where is that? Can we
that
get it?
page 65, Lordship.
Page 56.
Page 65, Lordship. Page 65. I'm just taking, Lordship, to the operative portion of the judgment, Lordship. It starts from page 68, Lordship.
Page 68, yes.
The last paragraph I'm reading, Lordship. It will. A perusal of the record, it appears that the applicant is a borrower and had availed financial assistance from the respondent corporation. The corporation secured creditor invoked the jurisdiction of the tribunal by filing an application under section 19 of Recovery of Debts and Bankruptcy Act 1993. The said original application under section 19 was presented before this tribunal on 10/7/2018. Thereafter, notice summons were issued upon the defendant. It was observed that on 14/11/2018, the learned counsel has appeared for all the defendants, including the defendant number 6, by filing Ukalatnama and filed written statement without evidence on affidavit. Thereafter completion of pleading, the case was fixed for final hearing. But the learned counsel appearing for the defendant number 6 failed to appear before the tribunal. And thereafter, the liberty was granted to file written argument by both the parties. Accordingly, the judgment were passed on 8/9/2022 in absence of the defendant, and the learned counsel for the applicant has applied for the certified copy of the judgment on 8/7/2024, and finally on 15/7/2024, the certified copies of the present case was delivered to the engaged counsel for the applicant. Thereafter, the applicant has tried to explain the reason for condonation of delay on the ground that their engaged counsel took some time to communication. Lordship, may kindly take to the next paragraph. it is pertinent to mention that Section 5 of the Limitation Act is a statutory beneficial provision intended to mitigate the hardship of a suitor
from the
for
justified-
rigorous of limitation because the party may have the justification reason for not approaching the court on time. Section 5 enabled the court to admit an appeal or an application after expiry of the prescribed period on sufficient cause being shown for the delay. Since the sufficient cause has not been defined, the court are left to exercise the discretion to conclude whether the circumstance exists establishing sufficient cause. The only guided principle to be seen is whether a party has acted with reasonable diligence and had not negligence in presenting the matter. Each and every day of delay is to be satisfactorily explained. The next page, Lordship. It is apparent from the record that the petitioner has knowledge about the date of the judgment which was passed on 9/8/2022. It is also noted that the applicant was appearing in the case and has also filed written statement.
No, that's all right. So you were saying that it was against other, this is against the judgment.
Against a judgment, Lordship. That's why, Lordship, that section 20.
No. Then again,
21 would come.
No, like na, he found the application for delay. Paragraph 9. Order 9, Rule 13. That is what is it. Accordingly, the dates stand determined. I do not find any ground to grant waiver. CRT to order 9 Rule 13. It is paragraph. So not on the question of the merits of the judgment. Right. See, he says that he was impersonated.
Lordship.
So therefore, after 20 months, he came to know about it.
Lordship.
Is there any discussion in either of the orders that this claim of the applicant is wrong?
Lordship.
Nobody impersonate, just a minute. So this explains for 22 months and the warlike situation in Manipur with that strife between Kukis and Maithis. Right. So the DRAT is now not questioning the acha. This is and this he's counting the delay from which date? The rejection of Order 9 Rule 13 application.
No, he's counting the delay. He has given a reason that he came to know from another council that there is a judgment passed against him. He's an ex parte judgment.
It is not an ex parte.
It's not an ex, but he has termed it an ex parte judgment without his presence. So he came to know from that.
Suppose he is not the debtor. Asking for 2.2 crores to be deposited before limitation, but hear him on merit.
Lordship, if he's not,
hear him on merit. Who are you?
Lordship, if he's not a debtor,
you are from the bank.
I'm from the bank, financial institution. Lordship, if he's not a debtor, Lordship, then perhaps that question of that pre-deposit won't come, Lordship. If he isn't.
That's all right. So this, even if the debt has been determined, but this limitation petition is not on the determination of the debt. This is with respect, you destabilized us for some time.
No.
No. You made a right argument, but determination of debt is all right. If he challenges it on merits, he has to deposit. But before that, he has to cross this hurdle of limitation.
Lordship, since the debt, Lordship.
So what he should he be rendered
directly or indirectly?
Should he be rendered without an appeal?
Lordship,
can you? This is an order passed under Section 5.
Lordship.
It's not an order passed on merits.
Lordship.
And the judge has gone into the merits of the case, the appellate court.
Lordship, my respectful submission is that Lordship.
And limitation petition that comes later. with respect to this, suppose this is allowed, then the DRAT would be justified in saying that no, you are making an excuse. This is the determined amount you deposit, otherwise we'll not hear you on merit.
Lordship, directly or indirectly, he's challenging the judgment. Lordship, I found it relevant to place another judgment of a division bench of Madras High Court, similar fact. Lordship, ex parte judgment pass against the borrower.
We'll be tinkering with the law then. But otherwise, you see, this is one situation. Suppose somebody goes before the tribunal and prays that, well, apart from the merits, apart from the documents that we have said, I want to file additional affidavit. DRT says no. We will not keep on accepting such out. Against that order of rejection, if he goes before DRAT, there is no other forum available to him.
Lordship.
What happens?
Then, Lordship, he is not required to deposit 50%, because, Lordship, the judgment, because there will be no judgment. It will be stayed prior to the judgment. Once judgment has been passed, Lordship, the debts then determined.
That is a very genuine argument and ingenious argument that you've made. But then look at the discomfort which it can cause to a litigant in different fact situations.
Lordship, if Lordship takes the other act, the SARFAESI Act, Lordship, make a distinction. Lordship, there are two grounds on which Lordship, if he prefer an appeal, Lordship,
I'm thinking of one thing. We have followed that distinction between SARFAESI and this.
And this one, Lordship.
But the difficulty is that we are thinking it from the angle of a litigant, of a private so-called borrower, that 226 is not available to him. Civil suit is not available to him.
Lordship.
And if there is a ground where he wants to say, how then for all practical purposes, you are binding him with the judgment of DRT. He has no option to agitate, no forum to agitate. Is that not heavily loaded against the
Lordship,
borrower?
he ought to have filed a review petition.
If suppose he has not taken a loan, where from will he get to?
Lordship, if he has
huge amount.
Lordship, if he has not taken loan, definitely, Lordship, he can Lordship, establish the fact, Lordship, or he can move to the civil court. Lordship, he can move to the civil court, challenging the judgment.
Which civil court will take notice of it with the law? That is why we have.
But here he's a borrower, Lordship. That's the Lordship. I'm just relying.
Here we will say that this shall not be taken as any observation towards the merits of the case.
Lordship, there's a judgment from Division Bench of the Madras. I got similar facts, Lordship. I'm just placing, Lordship. It will help to certain extent, Lordship. Here, Lordship, same facts. There's an ex parte judgment. It was challenged by the legal error of the Lordship borrower, along with an application for condonation of delay, Lordship.
Just a minute.
Lordship, I have just marked paragraph 3, Lordship. I have just noted down the relevant portion. So, Lordship, you don't have to go to the entire judgment, Lordship. Paragraph 3, Lordship. I have just highlighted, Lordship.
Yes, you have highlighted.
Paragraph 3 and 4, Lordship.
Well, facts are pretty different. Here, before the tribunal only, there was an application under Order 9, Rule 13.
Yes, Lordship.
So he has also filed an application under Order 9, Rule 13. That has been dismissed.
That has been dismissed.
So he'll be challenging both the orders.
Lordship.
Now, he doesn't challenge both these orders. He has, but then before that, before DRAT can consider, the delay has to be condoned. That has been rejected.
Lordship, same thing, Lordship, here. Lordship, the application for condonation of delay was rejected by the division bench. Was rejected by the Your Honor, Learned Tribunal.
Here the application under Order 9, Rule 13 was rejected.
Along the condonation of delay application was
delay before the DRT only.
Yes, Lordship.
Not before the DRT. No, DRT.
DRT, Lordship. Application for condonation of delay before DRT was rejected, Lordship.
No, just a minute. The Order 9, Rule 13 application before the DRT, that was allowed or dismissed?
Lordship,
I mean, that must have been dismissed, but was it entertained?
Lordship,
Not entertained.
Just
Lordship, application on order 9 rule 13, along with that he filed an application for condonation of delay. His delay was not considered by the tribunal, against which he preferred an appeal to the appellate tribunal at Madras, Lordship. The appellate tribunal, Lordship, since it was an appeal, Lordship, the appellate tribunal imposed that 50% pre-deposit.
And what is the delay?
In this case?
In this case, Lordship, he by a self-proclamation, he cannot say that delay is 36 days. According to him, it's a 36 days delays. But according to us, is a more than, Lordship, 2 years delay, because he have entered APR and summons were duly served. It was a contested case.
Where will he go? Where we will say that you don't
Review application is there, Lordship. Review application, there is no such hurdle that he have to deposit and all this thing. But only question is limitation, Lordship.
Yep.
So why does he say this? See, look at this. In the present case, the date has already been determined. I do not find any ground to grant waiver. No. Just a minute. This application under Order 9, Rule 13 was dismissed when? Application under Order 9, Rule 13 was dismissed by the DRT when?
It was not entertained also.
So it was not entertained. So therefore, the limitation petition was dismissed when?
Yes.
Yes,
On 11/6/2025.
11/6/2025. 2025. You filed, you raised the challenge before DRT when?
DRAT, it was one time, but yes.
It was within time.
It was one time, but they insist on for filing a condonation application also there. And their condonation application was allowed. And I said that my appeal is not a regular appeal. Section 20 of the DRT Act, it says that appeal may be regular appeal, it may be misappeal. Yes.
ये तो मेरिट पर डिसाइड no. So therefore you will see. Question is that what 9 to 13 should it be applicable for the why can't this be decided by DRA? DRA तो पार्टी बनाता है. Registrar of the debt recovery appellate. No, that's the formal.
Also, I have a judgment on the Telangana High Court. So I have placed.
He has a judgment from Madras High Court.
And mine is exactly the same.
Now we will give you a judgment from Guwahati High Court.
Yes, sir. I have a judgment which I placed on the court. Kindly furnish. This is exactly the same. And the Honorable High Court of Telangana says that Section 21 is not attracted to, because what is challenged is a misappeal against the condonation delay. Against the condonation delay. What I challenge before the appellate tribunal is the condonation delay refusal. the rejection of my condonation of delay. Once condonation of delay is allowed, thereafter, my miscellaneous application before the TRT Guwahati should have been registered, and thereafter it should have been disposed in accordance with law. This is what I want. Now they say that I was present. Now he says that I filed a written statement, everything done in my absence. And what Order 9 Group 13 says is about serving of the summons, duly serving summons. Was there duly service of summons on me? My application was that the summons was not duly served upon me. And therefore I did not engage. I did not know about any such case pending before the TRT Guwahati. I did not engage any advocate. And if they say that, yes, your matter will be registered, and we'll make an inquiry. And if they
Where is the judgment of the DRT?
Yes,
Not this, the original judgment, determination of.
yes, Lordship. Page 49, Lordship. The property portion that is recorded at page 52, Lordship. First, second, third paragraph, Lordship.
Page 52.
Page 52, third paragraph, Lordship, from the top. After filing the original application, the tribunal issued notice upon the defendant through registered post, and the applicant bank filed service report and brought on record the postal receipt. The learned counsel for the applicant bank submitted that service of summons has been served upon the defendant. Thereafter, the learned counsel for the defendant have appeared on 28/8/2018 and filed joint written statement on 14/11/2018, to which the learned counsel for the applicant bank filed rejoinder on 5/2/2019. Thereafter, the matter was posted for hearing.
ये DRT कौन सा है? DRT DRT कौन सा है? कोई DRT नहीं, आइए नंबर नहीं तो करो DRT कौन है? DRT तो आप along with no, we are allowed. Otherwise, he has no option. Decide the matter. It is there, but without the prerequisite of the past. Otherwise, get what? Hey, we have what's your name?
N. Mahendra.
We have heard Mr. N. Mahendra, learned advocate for the appellant, huh? Learned advocate for the petitioner, and Mr.
G Das, Lordship.
G. Das, learned advocate for the respondent bank.
Financial Corporation.
Respondent slash financial corporation. Your respond number?
1.
Slash respond number 1. The respond number 1 slash corporation had filed an application before the DRT under section 9 of the Recovery of Debts Due to Banks and Financial Institutions Act 1993 for issuance of a recovery certificate of an amount of rupees 1,85,92,866 only against all the defendants, including the appellant herein, jointly and severally, with pendentolite and future interest as per the contractual rate, till the realization along with the cost and other reliefs. The tribunal, with a reasoned judgment, held that the respondent corporation had been able to make out a case that the defendants, including the appellant herein, are jointly and severally liable to pay the amount stated above, and hence issued recovery certificate accordingly for the same amount in favor of the respondent corporation against the appellant and others. The judgment was passed on contest. However, later, the appellant herein, claiming that he was impersonated and that he had never participated in the proceedings, filed an application under Order 9, Rule 13 of CPC for setting aside / rescinding the judgment of the tribunal, along with an application under Section 5 of the Limitation Act, explaining the cause of delay in preferring such application under Order 9, Rule 13 of the CPC. The learned tribunal, by the order dated 11/6/2025, observed that the records revealed that the appellant herein / applicant / borrower had availed financial assistance from the corporation, which had invoked the jurisdiction of the tribunal by filing an application under Section 19 of the Recovery of Debts and Bankruptcy Act 1993, which was allowed on contest. The judgment was passed on 8/9/2022. In absence of the defendants / appellant herein, but the certified copy for the judgment was applied for on 8/7/2024, which was handed over to the present appellant on 15/7/2020. The tribunal also discussed the grounds raised in the application for condonation of delay, but did not agree to condone the delay for accepting / entertaining any application under Order 9, Rule 13. on the ground that the appellant slash applicant therein had knowledge about the date of the judgment, which was passed on 8/9/2022. And that the applicant slash appellant herein had appeared in that case and had also filed written statement, which means that the appellant had full knowledge about the case, but was negligent in appearing in the matter. After giving sufficient time, the tribunal had pronounced the judgment, and such application under Order 9, Rule 13, along with an application under Section 5 of the Limitation Act, was filed after 22 months. Now, after more than 2 years, thus without entertaining the application under Section 5, under Section 9, Rule 13, under Order 9, Rule 13 of the CPC, the application for condonation of delay was dismissed. The appellant herein preferred an application. Appellant herein challenged the order of dismissal of the condonation petition by the tribunal before the appellate tribunal, which, according to the appellant, tribunal, and the appellate tribunal insists for now a pre-deposit of 50% of rupees 2.2 crores for entertaining the appeal as mandated under Section 21 of the Recovery of Debts and Bankruptcy. Of the, what is it? Reconciliation.
RDB Act.
This Act of 2002. DRT.
1993.
Recovery of Debts and Bankruptcy Act 1990. The learned counsel for the appellant herein, jahan likha hua petitioner herein karna. The learned counsel for the petitioner submits that what was challenged before the DRT, what was challenged before the DRAT, what has been challenged before the DRAT is not the judgment regarding determination of the debt liability, but the refusal to condone the delay in preferring an application under Order 9, Rule 13 for rescission of the judgment. 13 CPC for rescission of the judgment. He has further submitted that the tribunal passed the order presuming that the petitioner herein was the borrower, whereas the petitioner claims to have been impersonated by somebody else masquerading as him, by somebody else as masquerading him. Thus, the grounds given by the tribunal for rejecting the application for condonation of delay was under challenge before the appellate tribunal. The pre-deposit requirement under the RD and Bankruptcy Act 1991
93
does not apply if the appeal is against any interlocutory order, or for refusing condonation of delay, or for refusing amendment or restoration, or any procedural order. The provision contained in Section 21 of the RD Act, so-and-so Act, is being extracted herein for the sake of completeness. The pre-deposit requirement, comma, it becomes clear from a plain reading of the section, applies only when the order appealed against decides the liability or quantifies the dues. Stop. Interlocutory or intermediate orders like rejection of the application under Section 5 of the Limitation Act or rejecting any application for filing additional evidence, etc. are exempt, ought to be exempt from such requirement of depositing 25%, depositing of such requirement of pre-deposit for entertaining the appeal. In several cases of the Supreme Court, it has been clarified that Section 21 of the Act triggers only when there is determination of liability. And the embargo does not apply if the appeal is not from a debt determination order. Mr. Yodas, Mr. Das, learned advocate for the respondent bank, however, submits that there was a determination of the liability holding the petitioner herein as one of the borrowers, and therefore the tribunal had rightly rejected the application under Order 9, Rule 13 of the CPC, along with the application under Section 5 of the Limitation Act, which order primarily confirms and substantiates the determination of the liability against the petitioner here. We find ourselves unable to agree to such a proposition for the reason that the order challenged before the appellate tribunal was the rejection of the application under Section 5 of the Limitation Act by the tribunal. By the tribunal. The tribunal, by the appellate tribunal. The appellate tribunal is only required to go through the reasoning given by the trial court, given by the tribunal for rejecting such an application. In that case, it would be unfair to the petitioner to demand, unfair to the petitioner to coerce him into making the prerequisite deposit of 50% of the determined liability. More so when the petitioner has claimed it to be, petitioner has, in his application under Order 9, Rule 13 before the tribunal, has claimed to have been impersonated by somebody else. Considering this aspect of the matter, we allow this application, requesting the appellate tribunal not to insist for the prerequisite deposit under Section 21 of the Act, and hear out the application, hear out the appeal against the order, hear out the appeal of the petitioner against the order of rejection of the condonation petition by the tribunal. The order accordingly, the application stands. Yes.
Item 20.
Yes, Mr. Chaudhary.
Yes, madam.
Was Mr. Gogoi wrong?
Milord, will kindly give me 10 minutes time, Milord. Possible, kindly give me 10 minutes time. Let me place it, Milord. I've taken the instruction from the client, my lord.
Huh? What?
I think we'll have to press for it, my lord.
No, you press for it.
Yes,
It's not
yes,
difficult.
okay.
We'll hear you on some other day.
Yes, yes. My lord.
Some other date. Some other date in January. Then you press it. We thought that you have been given the basic
No,
pay.
no, my lord. No, my lord. Yesterday I have checked up, my lord. The order itself is very craftily drafted, that 158, my lord. They say they will give increment, but if on the higher side, no. Just have a look once, my lord.
If on the higher side, what?
My lord, supposing, my lord, earlier our
No, no.
initial.
Do they say that if it makes your salary more than 50,000,
Yes.
they will not give the.
Yes,
And they are giving that increment to the doctor.
doctors.
Then you can't.
That is.
Withdraw. Yes, Mr. Gogoi, what do you have to say?
Well, in that case, I will also have a specific instruction, my lord, because my lord, they say, my lord, we'll go by whatever is there in the speaking order.
No, but then suppose.
You should go by the order of the learned single judge in the earlier rounds.
You make a statement, we decide it now. You make a statement that whatever increment is being given on the slab of salary to the allopathy doctors,
Yes.
that is admissible to him also because he has been given the minimum basic, he has been given the same pay parity
Lordship.
as an original entrant in this service.
Lordship.
Say that we dispose of this. That's not required.
That will I place the written in that case, my lord.
Take it.
Ultimately, it will.
Yes, as jointly prayed for.
My lord.
Re-notify this case. But we have not said anything again on that date. You will argue other things.
Lordship, I will place the written instruction specifically on the increment part.
And
My lord, my only humble
please
submission
remind
is
us that this
the
was the-
learned single judge, the earlier round of litigation says we should be paid at par. That's all, my lord. Yes, if somebody is senior to me, he will get more increment, therefore he is paid the higher. That's a different thing. But it can't be somebody is getting 90,000, I am getting 50,000. Because in the order they have very craftily said, my lord, only the difference will be paid. If it is less, it will be paid. If it will be on the higher side, it will be adjusted.
Take it. We have. Let me give some introduction to the facts of this case. Otherwise, on the next date, we will be at a loss. What did Mr. Chaudhary argue or what Mr. Gogoi argued? We have heard Mr. Ken Chaudhary, learned senior advocate for the appellant, and Mr. Gogoi for the respondent state. There is a long-standing grievance of Ayurvedic doctors employed under National Health Mission in Assam who seek pay parity with the allopathy (MBBS) counterparts. The refrain of the state is, the response of the state is that they have already been paid in this, they have already been put, that the petitioners have already been put in the same pay slab as the MBBS doctors, making their pay 50,000 rupees per month, which is the pay given to MBBS doctors at the entry level. However, Mr. Chaudhary, learned senior advocate, has pointed out that they are denied the benefits of increment if addition of such increment would make the pay slab exceed rupees 50,000.
Exactly.
However, the MBBS doctors are getting their increment, and many of them are being paid an amount of 90,000 or above. Mr. Gogoi, learned counsel, learned advocate for the state, seeks some time to take clear instruction in the matter. Re-notify February.
Lord.
12 February.
Then Mr. Chaudhary may have a case.
Yes.
Unless you come with a reason why you will not give them increment.
Lord. We are giving, my lord, but let me have a written.
Yes. Now you can't make an oral statement here. Yes.
Daily list for hearing item 8.
Lordship,
My senior, Mr. H.K. Das, is on legs in another court. Finally, after some time.
No. Today, the heavy board today, we will not, what did I say on the last date? They're dismissed.
Lordship will see the order dated 4/9/25, Lordship.
We have said something.
Yes. Lordship wanted some judgments from my side. I've given 3 judgments, Lordship. They are there. And so far as the stand of the petitioners.
So we said that we are of the prima facie view that an organization or a body created by a statute or under statute would come within the purview of definition of state, but would not ipso facto be treated as a state for ancillary purposes such as payment of pension. And you have brought judgments.
I have given 3 judgments, Lordship.
Which are those? Well, let's conclude it quickly.
Or some other day, Lordship. My senior, it's a complicated matter, Lordship.
Friday?
Friday is not on Friday, Lordship.
Lordship.
Not on Friday, Lordship. Friday, I may not be here.
A prayer for Passover has been made on behalf of the writ petitioner on the ground of non-availability of Mr. Das at the moment. Considering the heavy board today, the same is not possible. Mr. R.K.D. Chaudhary, Learned Counsel for the Central Government, is present. Let this matter come up for consideration on your date in January. Mr. Chaudhary, what did you argue before the other bench? The order is peculiar. You argued something?
No.
Very unusual.
No, Lordship, what had happened is.
No, look at this order.
Yes,
You have the order before?
I have that order.
My brother has just pointed out.
Yes.
I don't know, how can you interpret the order or how can the bench consider this to be a...
Lordship, I was of the impression, Lordship, that I have to file an affidavit.
That you may entertain that petition, but that was not necessary for you to say, and it was not necessary for the bench to record it because we don't say, we don't pass vague orders. We make it very, our effort is to make the order clear. It should not be ambiguous on any count. Mr. R.K.D. Chaudhary has submitted that as per his understanding of the order. You did not want to argue the case then?
No, Lordship.
Why this interpretation? Clear, and you were not supposed to give any judgments. Mr. Das was supposed to.
No, Lordship will see the last paragraph of the order passed by your Lordship.
Mr. Chaudhary, Learned Deputy Solicitor General, shall also bring on record judgments of the Supreme Court which makes it. Where is the procedure for bringing judgment by affidavit?
That is what, Lordship. That is what, Lordship.
Then the mistake is on your part.
I apologize.
Not on the part of the bench.
I apologize, Lordship.
All right. All right.
28 January. 20.
Yes.
Lordship, I beg to appear virtually in the next meeting.
Item number 10.
Yes, Mr. Kyal.
Lordship, I make inquiry. Till date, no notification has been.
So therefore, we will say that any person aggrieved by such refusal of ICT shall, it would be open for him to contest it and it shall be decided after giving all opportunities and looking at the documents of payment of tax. To that extent, we will not even read down, but in cases where it is denied, constitutionality, we will say that it is absolutely constitutional because such fetters can be put. But till the time CBIC comes with any such circular as it was till 2022 or 23.
Lordship, 22, 1st January 22.
22. Then till such time, this is the advantage. We are not diluting the provision, not at all.
Not.
All
Lordship,
right,
16
yes.
to, Lordship, reading down as a had, Lordship, on the last occasion, your Lordships had indicated to
cannot-
this extent, 16 to double A has to be read down, Lordships.
No, we are not reading it down. We'll only say that in case any person gets.
Lordship, 16 to double A, Lordships, the mechanism to communicate with my supplier, there is no
That's all right.
mechanism in place under section 38. I brought your report to your note, Lordships, that
That's
there
all
is no
right.
mechanism in place. And therefore, unless the CBIC brings out the circular in the same lines, I cannot be held guilty if it is not appearing in my 2B, Lordships. Therefore, to that extent, the reading down was.
We will say that this restriction, untrammeled restriction, is iniquitous because the burden is very onerous on the purchaser.
Lordships, and there is no mechanism of communication under section 38.
However,
That is
since
the
the
flaw.
object and purpose of the amendment in the Act is to prevent fraudulent ITC claims and to promote supplier compliance, we will not
Lordship.
hold the amendment to be unconstitutional, but for the
Lordship.
present, we'll read it down to the extent.
Lordships. That is my only play. Lordship, I have placed before your lords. I am not asking for constitutionality, only the reading down to that extent.
Read it down to the extent that no, it shall not be given to you. But to a bona fide purchaser will be given opportunity to prove his bona fides.
Yes,
Lordships, and 16 to double A, Lordship, the communication, the line, that communication under 38, there is no such communication in the law.
That we have said, that is the base point on which we have proceeded.
Lordship, that is what I have argued before your lords. Nothing more,
So
nothing
we
less.
read
Lords.
it down only to that extent.
Lordships.
Application disposed of.
Much of.
Lordship, my written notes was on record, Lordship. It was a pleasure
Yes, it is on
appearing
record.
before your lords.
All right.
It was always a pleasure appearing before your lords. Thank you. Much obliged.
Pleasure with us also.
Grateful to your lords. Much obliged.
ये मेरे पास भेजो उसमें है रिटन नोट के साथ ये भेजवा इसको भी देना ऐसा कभी लिखा था नाइस नेम यस 1 बजे के बाद हम ले लेते हैं ऑलमोस्ट फिनिश यस
Item 13.
ये तो
May I please your lordship?
Yes, Mr. Borgohain.
My lord, I have gone through your lordship. The last time your lordship has referred to the judgment of Gurvinder Singh. I've gone through it.
Which
My lord,
judgment? I said
lord.
NIA versus Vernon Gonzalez.
Yes, my lord, we have gone through it. The thing is that in all these judgments, they have not interpreted the provision of 42D5. They have said,
I think Zahur Ahmad Watali and Vernon Gonzalez, they are very clear.
my lord, your lordship, I will.
Constitutional validity has been upheld.
No, it has not been upheld. Your lordship, can kindly come to Watali. Watali judgment. I've given it. I've already given
Mr.
it.
Borgohain, the time that you are available physically, argue this case.
Then,
Difficult
my
to
lord, in that case, any day in the month of January, my lord?
February.
My lord, then I will give a compilation.
Why can't you? Therefore, you must come and argue. For
No, my
compilation, you'll have to come.
Yes, my lord.
You are arguing from Delhi or Nagaland?
Nagaland, my lord.
Let this matter come up for consideration on some date in February.
17 February.
Obliged, my lord.
We see our understanding of Watali is that the constitutionality has been upheld.
But in Watali,
we will
my
hear
lord.
you.
My lord.
17 2.
See, even though the statements made in that judgment is in it is a parenthetical, explanation. Nonetheless, it is binding, and then we will not like to reopen it. Nasib also, everywhere the constitutionality. See, in Watali, the very constitutionality of that prerequisite for consideration of bail in UAPA was considered. So unless it were held to be constitutionally valid, facts would not have been discussed. So we would not say that it was only a parenthetical remark. It was basically a consideration of the constitutionality.
But in Watali's case, I find out one thing very
You
interesting.
are making some efforts on the next day instead of we or you
No,
are wasting our energy. You give the compilation, give a short note of argument, we will decide.
My lord. Next, my time is also there.
Hmm?
Yeah, another matter is there. You were supposed to.
Item 14.
Yes, my lord. Item 14.
Yes.
My lord, Mr. Mishra is appearing in this matter. He is in court number 16, my lord.
Who is appearing?
Come back. Senior Advocate DK Mishra. He is I've come online, back. madam. He is online, madam.
Mr. Balgopal, you are appearing from whom?
State respondent.
Nagaland.
Nagaland.
And Mr. Chaudhary, you are appearing.
I'm also appealing for the director, Commissioner Secretary. Actually, my lord, initially I was appointed when the question of rule came in. Then this honorable court wanted the presence of honorable advocate.
Let's see, what did we pass some order?
No, my lord, there is a stay order operating.
Oh.
That's the problem.
And it is operating against me, my lord.
Of the case.
My lord, I am
Operating
appearing
against me,
for,
my lord.
I am appearing for the petitioner in this case.
Yes.
And this matter was heard a number of times.
No.
The first time the interim order was passed on 7/9, and thereafter the matter was taken up again on. Your Lordship will kindly see your Lordship's order dated 3rd of May 2024. 3rd of May.
Vishnu is our state. Vishnu is our state.
The matter was fully heard, my lord, and after that, your Lordship passed this order confirming the interim order. Now, therefore, the entire matter is ready. In fact, I don't know if your Lordship will remember. Last time, your Lordship will say this will be on the top of the list today. But then I found, my lord, that it was not so, and it was listed as item number 14. Meanwhile, I had a case in another court.
No,
So
no
the moment
difficulty. If you have no difficulty in arguing it this virtually, we will hear you now.
My lord,
If you want to argue, we will hear you now.
I will argue. My lord. I'll place my case.
Yes.
But it's going to take time. This is what I'm trying to tell my lord.
Our time is meant for this only. So
No,
if you don't,
that's okay. Then that is clear. I have no difficulty. I'll place. I'll place.
Mr. Balgopal, Mr. Chaudhary.
I won't take much time.
Yes, Mr. Yes.
I'll begin.
Oh.
I was looking in the other case that time. This case. Give me just 2 minutes. My lord, by this application, I'm challenging the constitutional validity of Nagaland Land Resource.
Yes. Nagaland
Development
Land Resources.
Department's Service Rules 2008. 2008. If your lordship permit me, I'll just give the short background of this case. Because this is second time that I'm coming before your lordship.
All right.
Now, my lord, your lordships are aware that the government of India undertook Wasteland Development Program to develop 49.79 million hectares of non-forest land, adopting multi-pronged approach. And the program was, my lord, named as Integrated Wasteland Development Program.
No, sir, Mr. Mishra, can I ask you to focus your, I mean, it's up to you. We have no problems, we can hear you. But let us see the constitutionality of the rules which you have challenged, on which ground, that background fact, how Land Resources Department came to be a department with the government, that would be relevant so far as we are concerned. We will test the constitutionality on the set parameters for testing the constitutionality.
And that your lordship will have to do, but my only concern is that the validity cannot be challenged in abstract. There are facts.
Not at all. It can't be challenged.
So therefore, my lord, if your lordship,
but what we are suggesting to you is this. I mean, in deference to your age and experience, we will not be asking you again for changing your mode of argument. We will hear you the way you would like to proceed in the matter. If,
Madam,
if, if a young, if a young, just a minute, if a younger advocate or maybe Mr. Bourgoin or somebody else would have argued in his way, we would have made him go through by our choice. But for you or for other senior advocates who are sitting here, Mr. Bal Gopal and Mr. Chaudhary, we will allow them to have their own way. Now look at this. Look at this now. The difficulty is with respect to the extension wing officers who say that they are being excluded for their determination to come to the higher post of deputy director.
Absolutely.
So therefore, this is not a discussion in abstract. You tell us where is that rule, where is that prescription, and then we will test it whether it is good, bad, worth interfering or whichever.
All right, if your lordship desires, I'll straightway go, my lord, to the rules.
Sir, we will suggest one thing subject to your approval.
My lord,
can you just ask your junior to make a short notes of your argument so that we see it point wise and then we don't
my lord,
trouble you
if your
for
lordship,
long.
if your lordship can have another date fixed, because I was not expecting this case to reach, because since it was not the first time.
All right. Why we say so?
Give me any date according to your lordship's convenience.
We will give you a short date because there is a stay order operating. Normally we are of the view that any statutory prescription ought not to be stayed. Either it is set aside or it is allowed to remain on board.
My lord, on 3rd of May, I was heard for about 45 minutes by division bench presided over by Chief Justice. And then I was stopped saying that will take time. We'll make it absolute.
No, even if it takes time, we will.
Very well. Then your lordship may give a short time as per your lordship's convenience.
And Mr. Mishra, we would request you to shorten your argument so that we don't get involved with maze of facts which may not be necessary. Just the facts which are essential for deciding the matter. That is our request. If you don't want to do it, we will go by your way.
No, I just want to point out that we challenged this in 2020, their rules. Then there was an agreement.
That's all right.
I know the challenge will not be
Mr. Mishra, can there be an agreement with respect to a statute between the government and the association?
Saying no, but that will, my lord, demonstrate the conduct of the state.
Conduct of the state in reneging from its promise. That's one thing. But so far as
conduct is very important. Conduct is very important, my lord.
You'll have to deal with this.
All right.
Look at this. Look at this. Now, let me give you the vague memory that I have of what we saw it on the last occasion.
Yes.
That there was an agreement between the government department, the Department of Land Resources, and the association of the extension wing officers.
Both the wings, technical and extension.
The government agreed that no, they would provide the feeder post for the post of deputy director. And then they came out with another stipulation which only favored the technical wing officers. So one of the grounds is that the government has reneged from its promise. What kind of promise is this against a statute for a statute?
I quite understand. That's why I said in the beginning, it will only show the conduct. Otherwise, it has to be on its merit.
All right. So
because there is an agreement.
Mr. Bal Gopal and Mr. Chaudhary, you also.
And my lord, again, this time your lordship will pass orders. Let it be on top of the list. I'll come.
It will be post this on priority. But before that, you give your notes so that
I'll give my note by day after tomorrow.
No, not so fast, Mr. Mishra. We are keeping it in the month of January or February. So the stay, whatever has been given, will continue. We will not pass any order saying anything. Now, what you have to do is that you ask your juniors to prepare it in a concise manner. It can't be done in a day or two because you have to exclude many facts. And then we shall decide on the day when you come prepared with notes in advance, we will decide.
As far as respondent 6 is concerned, my lord, there is already a note.
we're asking Mr. Mishra, you people can be, we can ask you to stop argument, huh? We will deal with in our own way. Look at this, the interim order, if it has to be vacated, we must hear it. Therefore, we are fixing a short day. We can't vacate an order in a jiffy. And there is some kind of sanctity to the orders passed, whether we agree or we don't agree.
You are just handing over the complete details page wise. Just for
Mr. Liko,
lordship's
on behalf
reference.
of the state of Nagaland. Yeah. Again, let this matter come up for consideration on priority. Which date? January, if it's okay for you, otherwise February,
Why not?
January.
January.
First week of February would be a little comfortable, very cold.
You can have it on 7th, there are other.
Of
Yes.
February. 7th of February.
7th,
Yes.
7th January.
7th
yeah.
is Saturday.
No, 7th Jan would be too cold for Mr. Mishra. Again, he'll be sitting in his room and arguing on this.
No, I want to be there when the matter is taken up.
Yes, we'll appreciate that and we'll be very happy to see you, but in good spirits. So January is too cold.
Yes, my lord.
All right. And so February, first week?
February first week will be all right.
February 1st.
My lord.
5-2. Yes, 5-2.
Obliged, your lordship.
Obliged, my lord. Great.
Item 15.
May I please, Lordship?
Yes.
My lord, this is an appeal against the order of dismissal, my lord. What happened after the dismissal by the Honorable Single Judge, my lord, the trial court has given the judgment in the criminal case.
Mr. Purkayas, now let us argue law. The facts are that on 3 occasions, you deposited the amount which was meant for others in your bank account. On 3 occasions. Facts which have not been disputed. There could be confusion, there could be misunderstanding. You returned that amount. Correct? That also we know. Because you had argued on the last occasion. You were put to a departmental proceeding. You were dismissed. Your major concern was, your contention is that you have not been afforded, you have not been given the opportunity to cross-examine the witness through a lawyer.
This is one aspect.
Did you make any specific request and was it refused? No. The bank also did not have a lawyer. Okay, this is one aspect. Second aspect is that you were not given the list of those unlisted witnesses who are to be examined. The court says, the single judge says that they have been cross-examined. Once you cross-examine them, can you take this plea? 3, quantum. Vis-a-vis others, that is no reason. Deposit was in your account.
Yes.
Your complicity may be with the help of others, but you're the linchpin. You're the linchpin. What ground do you have now to challenge the order of the learned single judge confirming the dismissal of service? It's a very tough decision to take, Mr. Purkayas.
Yes.
It's a very tough decision to take. Somebody's life, his family would suffer. But then law is law.
My lord, first of one, my lord, I was not the depositing person. It was deposited by the officers. I'm the clerk. Honorable Single Judge has designated me as the officer, but I am not the officer. In that checks, I have not put any signature. It is signed by the higher authorities of the bank, my lord. This is one aspect. Now, secondly, my lord, during the trial departmental proceedings, I opted to, my lord, cross-examine those signatories, but they were not allowed. This is the second aspect. And the same thing they have not done in the criminal proceedings also. That is recorded by the Honorable Trial Court.
Sitting, we are not interested. GM, don't press GM tank always. No, it's not current position of law.
But the thing is that, my lord, they have, the petition appellant has refunded whatever deposited to his account, my lord. And he has not, my lord,
आप पता नहीं whether you people know this very oft quoted statement. अमानत में खयानत अगर 1 मिनट के लिए भी है तो ऑफेंस है.
I leave it to lordship because the lordship is has the power to modify the punishment, my lord.
The power is there.
Yes, lordship has the
But,
power to, because the other,
But the power is exercised with a lot of restraint.
yes, I also
This
admit it.
quantum thing was never in vogue before Ranjit Thakur's case. This has been brought through backdoor, but nonetheless, it has entered our Indian jurisprudence and service jurisprudence, but only when it shocks the conscience. And the conscience is not so fragile that it will be shocked by these things. In fact, the conscience would be shocked if there is an interference in the quantum at the appellate level, when one fact stands undisputed that the amount which was not meant for you was deposited in your account. Whoever has done it.
Yes, those who have, my lord,
And you being an employee, forget about officer, you being an employee, it's a situation of complete trust. Uberima fidus.
yes, lordship.
Complete trust.
After all, my lord,
बहुत खराब है ये, because this is how the banks are being bled to being non-functional. See, these officers of the banks, they are not careful while allowing a loan application. And most of the times these loans become bad. You see, they are in a hurry to show that yes, we have brought in so many numbers of business
yes,
without really assessing its viability, and it goes bad. Then you file case. You are, these are the persons who are fomenting this litigation. No? They are adding up to the litigation, DRT, DRATs, High Court, Supreme Court.
my lord, the thing is that, my lord, those who have,
Look at this, Mr. Purkayas. Bank and police. ये दो चीज बहुत difficult है. Life is a lifeline of the
Yes.
citizenry. इसमें कहाँ, there's no way out. Which bank will keep you as your employee,
my lord,
Can we say that no, because Mr. Purkayas argued very well, therefore we have changed the quantum. We
No,
can't.
no,
No,
no, I'm
our
not-
our hands are fettered.
I'm not on that, my lord. Your lordship, instead of, my lord, dismissal, your lordship may convert it to compulsory retirement at least, my lord, because this will at least, to some extent, this will, my lord,
It will
save.
not be sustained. The bank will challenge the order judgment in Supreme Court. Supreme Court will say.
That will be, my lord,
The
future
division
course of
bench
action.
has gone beyond his remit.
At least, my lord,
Even if we attempt to do that, you will not be benefited. Had it been against a private party, perhaps he would have said that, oh, all right.
my lord, to some extent,
Guilt
because he is, my lord, just,
Dismissed. उनके पास दे देना, हमारे पास देना ही नहीं.
Item 16.
I will meet your lordship. But
Yes.
due to some personal difficulty of my senior,
Who is your senior?
PJ Fukon lordship.
PJ?
PJ Fukon.
Yes. What happens?
Lordship, also we have also informed the other party also. Would like to adjourn the matter till 6 January lordship. If possible, taking up the matter on January 6.
No. You are appearing for the respondent.
Respondent number 1 lordship.
You'll have to argue. In fact, the appellant has a better case. Prima facie.
The allegation against whom made, my lord, he has not made a party here in this case.
No, that allegation, that is a different thing. Mr. Mahanta, we will not go more on that. One person who was co-opted as governing body's nominee as an expert, the respondent questions the competence,
but
after participating in the interview.
Yes, exactly.
It was, the marking was composite by the entire board.
Yes. And even my same mark has been given by the that mark.
How the judgment was, let's see. One more. कौन है जजमेंट कौन लिखा है? There are so many judgments. इनका judgment कौन लिखा है? Mr. The post is still lying vacant.
No, I am occupying, my lord. There is no.
Asha, you are occupying.
Yeah.
Then we can grant time.
My lord.
Then we can grant time. These are tentative observations.
My lord.
If you argue, we will
My-
see. We will see. We may sustain the judgment. And the prima facie, it appears that it was an overreach.
That is
After participating, he being selected, the margin of marks being only one or two, and then you question somebody. That way, many of you advocates can question our wisdom and say that, well, how has he
No,
been
they are-
appointed as a judge?
simply he is a
only
DA, that's
BA, LLB, somebody is LLM. As prayed for on behalf of the respondent and agreed to by the council by Mr. Mohantal and its senior advocate for the appellant. The matter is adjourned to give a date in February. He is still continuing.
My
as a-
19 February.
All right.
Oh,